Understanding sales and purchase agreements, SPAs. A sales and purchase agreement, SPA, is a fundamental legal instrument that formalizes transactions between buyers and sellers. While SPAs are most commonly associated with real estate, they are also prevalent across various sectors, such as manufacturing, retail, and finance. This article delves into the nuances of SPAs, elucidating their significance, components, and when they are necessary. Key takeaways. 1. Binding contract. SPAs are enforceable legal contracts, mandating buyers to purchase and sellers to sell defined products or services. 2. Widespread usage. Commonly employed in real estate, SPAs are also utilized for large single transactions or continuous orders of goods across different industries. 3. Comprehensive details. SPAs enumerate critical details, including the asset involved, sales price, payment terms, and other rights and obligations of both parties. 4. Due diligence. They dictate due diligence parameters and stipulate conditions to be met before transaction closure. 5. Breach remedies. SPAs outline remedies available in the event of damage to the product before the sale. What is a sales and purchase agreement, SPA? An SPA outlines the agreements made between parties and serves as a framework for negotiation up to the finalization of sale terms. After signing, the SPA becomes legally binding. It typically designates an independent third party to oversee the closing process, ensuring that the transaction adheres to all stated conditions and timelines. Contents of a sales and purchase agreement, SPA. The complexity of a SPA can vary significantly based on the size and nature of the transaction. Below are key sections often included in formal SPAs. 1. Asset identification. The SPA clearly identifies the asset involved in the transaction. For real estate deals, this includes specific details like address and parcel numbers. For other goods, the identification may be less detailed but should still provide clarity on the item being sold. 2. Purchase price and conditions. This section enumerates the total price agreed upon for the asset, including details on upfront deposits and the timeline for remaining payments. If contingencies affect the price or payment structure, those should be addressed here. 3. Due diligence. Particularly important for significant assets, this section encompasses acknowledgments by the buyer regarding the necessary investigative measures they must undertake to understand the asset's condition. It often includes indemnification clauses for protection against undisclosed issues. 4. Covenants and conditions prior to closing. SPAs typically specify essential actions that must happen before the sale concludes. Failing to meet these conditions can result in breach of contract, potentially allowing the non-breaching party to terminate the agreement. 5. Damages and remedies. This segment outlines procedures and recourses if the asset is damaged either before the sale or during transit. Different levels of damage may have varying responses defined in the SPA. 6. Confidentiality clauses. For transactions requiring discretion, confidentiality clauses specify how information should be managed, including limits on public disclosures and promotional communications regarding the sale. 7. Broker commissions. In real estate and large sales transactions, SPAs frequently include provisions regarding broker fees, detailing payments, timing, and responsibility for commission fees. When is a sales and purchase agreement necessary? While SPAs are not legally mandatory for every transaction, they are advisable, especially for significant purchases. Without an SPA, parties risk losing legal recourse should a dispute arise over the terms of a transaction or if one party fails to fulfill its obligations. For example, real estate transactions are intricate and generally require significant investment. A SPA protects both buyers and sellers by clarifying all terms associated with the sale. Corporate acquisitions. In mergers and acquisitions, SPA can delineate what aspects of a business are being transferred, thus protecting the interests of both buyer and seller. Examples of sales and purchase agreements. 1. Real estate transactions. One of the most prevalent uses of SPAs is in real estate. These agreements typically finalize the prices after negotiations and include other vital details such as the closing date and any necessary contingencies, such as financing requirements. 2. Supply chain agreements in corporations. Large corporations often utilize SPAs to manage their supply chain investments. For instance, a manufacturer might enter a SPA with a vendor to maintain regular supply of parts, locking in prices to stabilize their operational costs. 3. Asset acquisitions. When one company acquires the assets of another, an SPA specifies the tangible assets being sold while distinguishing them from intangible assets like trademarks or corporate identities, which might not be included in the sale. Conclusion. A sales and purchase agreement is an essential tool for defining the terms of sale between buyers and sellers across various industries. While not strictly required, having a well-drafted SPA provides essential legal protections and mitigates risks associated with transactions. Whether you're involved in real estate, corporate acquisitions, or large-scale procurement, leveraging an SPA is a prudent decision that can safeguard your interests and ensure clarity in business dealings.